You're listening to What You Need to Know About Estate Planning. This audiobook is educational. It is not legal, tax, or financial advice. Estate planning laws vary by country, state, and province, and your situation matters. For advice, talk to a qualified professional where you live. If estate planning makes you think of mansions and yachts, good news, it's not about wealth, it's about people, it's about control, and it's about preventing chaos on a bad day. By the end of this audiobook, you'll know what documents matter most, how to avoid common traps, how to protect your family, and exactly what to do next. Let's begin. Chapter 1. Estate Planning is a love letter with paperwork. Estate planning is what happens when you imagine the worst day and decide not to leave your loved ones alone in it. Most people picture a will. A will is important. But estate planning is bigger than a will. It answers questions like, if you die, who gets what and when? Who is in charge of making that happen? If you're alive but can't make decisions, who can act for you? Who makes medical choices if you can't speak? If you have kids, who raises them? If you own a business, who runs it tomorrow morning? If you have passwords, photos, crypto, or online accounts, who can access them? And here's the secret. Estate planning isn't one big decision. It's a series of small decisions, written down, so your life doesn't become someone else's emergency scavenger hunt. A lot of people avoid it because it feels morbid. But planning doesn't make bad things happen. Planning makes bad things less damaging. Think of it like installing seatbelts in a car. You're not inviting a crash. You're respecting reality. In the next chapters, we'll build a simple, strong framework you can adapt to almost any life. 1. Decide who should be in charge. 2. Decide who should receive what. 3. Make sure the right documents match the right assets. 4. Make it easy to carry out. 5. Review it as life changes. Now let's talk about the biggest myths that keep people stuck. Chapter 2. The myths that cost families time, money, and peace. Myth number 1. I'm too young for estate planning. If you're an adult, you're old enough to need at least the basics, especially healthcare directives and a power of attorney. Myth number 2. I don't have enough money. Estate planning isn't about money. It's about decisions. Even if you have only a car, a checking account, and a phone full of photos, someone will have to handle that. Myth number 3. My spouse will automatically get everything. Sometimes that's true. Often, it's not that simple. Rules vary, and blended families, children from prior relationships, or assets with named beneficiaries can change the outcome. Myth number 4. A will avoids probate. A will usually goes through probate. Probate is a legal process to transfer property after death. It can be straightforward or messy, depending on how you planned. Myth number 5. I made a will years ago. I'm done. Estate plans age like milk if you never revisit them. New baby, new marriage, divorce, relocation, business changes, a death in the family. Any of these can create serious problems if your plan stays frozen in time. Myth number 6. If something happens, my family can just figure it out. They can, but they'll do it while grieving, stressed, and sometimes disagreeing. When decisions aren't written down, conflict fills the space. Here's our goal. Not a perfect plan. A workable plan that reduces friction, delays, and surprises. Next, we'll talk about the foundation, the people who will act on your behalf. Chapter 3. Your key players, executor, trustee, agents, and guardians. An estate plan is a team roster. Let's define the roles in plain language. Executor, sometimes called a personal representative. This is the person who carries out your will after you die. They gather documents, pay final bills, file paperwork, and distribute what's left. Trustee. If you use a trust, the trustee manages trust assets according to the rules you set. Sometimes the executor and trustee are the same person, sometimes not. Agent under a financial power of attorney. If you're alive but can't handle finances, this agent can pay bills, manage accounts, handle insurance, and more, depending on the document. Healthcare agent, also called a medical power of attorney or healthcare proxy. This person makes medical decisions if you can't. Guardian. If you have minor children, a guardian is who you nominate to raise them if you die. Now the real question, who should you choose? A good choice is trustworthy, organized, emotionally steady under stress, and willing to do the job. The best executor isn't always the closest relative. Sometimes it's the sibling who pays bills on time. Sometimes it's the friend who keeps a binder for everything. Sometimes it's a professional, like an attorney or corporate trustee, if your situation is complex. 2 tips that save families. First, ask before naming. Don't surprise someone with a job that comes with deadlines and conflict. Second, name backups. Life changes. People move. People get sick. Have a second option. One more tip. If you have more than one child and you worry about fairness, don't assume split everything evenly equals no conflict. Equal can be unfair when needs differ. Fair can look unequal. That's why clarity matters. Next, let's talk about the documents themselves, starting with the famous one. Chapter 4. Wills. What they do, what they don't, and what to include. A will is a set of instructions for what happens after you die. A will typically does 3 main things. 1. Names an executor. 2. Names guardians for minor children. 3. Says who should receive certain property. But here's what a will doesn't do by itself. It often does not control assets that already have a built-in transfer mechanism, like accounts with named beneficiaries or jointly owned property. That's why people sometimes say, "But the will says," and the answer is, yes, but the account says something else. What should a will include? Your legal name and clear identity. Revocation language, so old wills don't compete. Executor and backups. Guardians and backups if you have minor kids. Specific gifts if you want. My grandmother's ring to my niece. A residuary clause, the everything else bucket. Signatures and witnesses as required where you live. A common trap. People write a will, then forget to update it after major life events, especially divorce, remarriage, new children, or a move to a new state. Another trap. People get extremely specific about personal property and create a battlefield. If you want to reduce conflict, consider a simple approach. Keep the will clear and focused, and use a separate personal property list where allowed to handle sentimental items. That list can often be updated more easily than a full will. Now, let's address the word that scares everyone: probate. Chapter 5. Probate, the process, the pain points, and how planning helps. Probate is a court-supervised process that confirms the person has died, the correct will, if any, is being used, and the executor has authority to act. Probate isn't automatically evil. Sometimes it's smooth, but it can become slow, public, and expensive, especially when there's conflict, unclear assets, or missing paperwork. Pain points families often experience: accounts frozen, bills piling up, delays selling property, relatives disputing who gets what, confusion about debts and taxes, a total lack of a master list of assets. What helps? Clear documents, properly signed, beneficiary designations that match your plan, organized records, and sometimes a trust-based plan. And that brings us to trusts, the topic that gets oversold and misunderstood. Chapter 6. Trusts, when they're useful and when they're overkill. A trust is a legal arrangement where one person, the trustee, manages assets for others, the beneficiaries, under rules you set. There are many types of trusts, but for most families, the most discussed is the revocable living trust. A revocable living trust can help assets pass outside probate. For assets titled in the trust, keep details more private, provide continuity if you become incapacitated, and make it easier to manage distributions over time. But a trust is not magic. If you create a trust and never move assets into it, often called funding the trust, then it may not accomplish much. When a trust is often useful, you own real estate in more than one state. You want privacy. You want to manage distributions to kids over time. You have a blended family and want clearer structure. You anticipate incapacity concerns. You want to reduce administrative friction. When a trust might be overkill, your assets are simple. Your beneficiary designations are clean and current. You don't need complex distribution rules, and probate where you live is straightforward. Here's the practical view. A will is the minimum foundation. A trust can be a powerful upgrade, but only if it matches your goals and is implemented correctly. Next, the documents people forget. The ones that matter while you're alive. Chapter 7. Incapacity Planning. The documents that help before death. Many families don't get hit with a death first. They get hit with a stroke, a car accident, a sudden hospitalization, a cognitive decline that lasts years. This is where incapacity planning becomes a kindness. The three common tools are: 1. Financial power of attorney. Allows your agent to manage finances if you can't. 2. Healthcare power of attorney or healthcare proxy. Names someone to make medical decisions if you can't. 3. Advance directive, sometimes called a living will. States your preferences about treatment, like resuscitation, life support, and comfort-focused care. A gentle but important point. These documents aren't about giving someone power over you. They're about choosing who can help you when you cannot help yourself. Without them, families may need court involvement, like guardianship or conservatorship, to get authority. That process can be slow and stressful. Incapacity planning also includes a real-world conversation. Tell your chosen people what you want. Don't make them guess at 2 a.m. in a hospital hallway. Next, let's talk about a hidden estate plan that many people already have, whether they meant to or not. Chapter 8. Beneficiaries, joint ownership, and the forms that override the will. Some assets transfer by contract, outside your will. Common examples: life insurance policies, retirement accounts, payable on death bank accounts, transfer on death brokerage accounts, jointly owned property with rights of survivorship, depending on local rules. These assets go to whoever is named, even if the will says something else. That's not a bug. It's a feature. But it becomes a disaster when beneficiary forms are outdated. Here are the classic mistakes. An ex-spouse still named as beneficiary. A parent named when you were 22, now deceased. My kids, listed without clarity, creating unequal outcomes. A minor child named directly, causing court involvement. A practical habit: once a year, do a beneficiary audit. Check life insurance, retirement, brokerage, bank accounts, and any transfer on death registrations. And remember, your estate plan is not just documents, it's documents plus asset alignment. Next, we'll handle the hard family stuff: blended families, unequal needs, and conflict prevention. Chapter 9. Family complexity, blended families, unequal needs, and avoiding fights. If your family is simple, one marriage, shared children, aligned finances, planning can be straightforward. But many families aren't simple. Blended family planning often needs extra clarity because there can be competing valid desires. You want your spouse protected. You want your children protected. You want fairness. You want peace. A common default plan is, everything to my spouse, and when they die, everything to my kids. That might work, but it can also fail if your spouse remarries, relationships sour, assets get retitled, beneficiary designations change, or long-term care expenses drain accounts. Tools that are often used to add structure include trusts with clear remainder beneficiaries, life insurance to equalize outcomes, specific bequests, clear rules about the home, and well-chosen fiduciaries. If you expect conflict, reduce the pressure points, make instructions clear, minimize interpretation. Choose a steady executor or trustee, and leave a short letter explaining the why. A personal letter isn't legally binding, but it can be emotionally binding in the best way. Next up, taxes, debt, and the "what about my business" questions, without drowning in jargon. Chapter 10. Taxes, Debt, and Business Ownership. The Big Picture. Let's keep this simple. When someone dies, there are usually 4 categories of money issues. 1. Final bills and debts. 2. Final income taxes. 3. Estate or inheritance taxes, depending on where you live. 4. Business or property management decisions. Debt doesn't usually get inherited personally by family members just because they're related, though there are exceptions and complications. In many situations, debts are paid from the estate before distributions. Rules vary, and this is where local advice matters. Estate taxes and inheritance taxes are highly jurisdiction-specific. Some places have none. Some have thresholds. Some have both types. If you might be near a threshold, get professional guidance early. Planning options are often best implemented long before death. If you own a business, estate planning must include a continuity plan. Ask, who can sign tomorrow? Who can access payroll? Who can talk to the bank? Who has the passwords? Do you have a buy-sell agreement? Do you want the business sold, transferred, or wound down? Even small businesses, consulting, online stores, rental properties, need a basic "what happens next week" plan. Next, we'll cover the modern world, digital assets, online accounts, and the stuff nobody can find. Chapter 11. Digital Life. Passwords, photos, crypto, and online accounts. A lot of your life is digital now. Photos, messages, cloud storage, subscriptions, domain names, online banking, crypto wallets. If your loved ones can't access it, it can be lost, sometimes permanently. What helps is not writing your password in a will, which can become public. What helps is a secure system. Consider a reputable password manager with an emergency access feature, a written set of instructions stored securely, a named person who knows where the information lives and how to find it. Make a simple digital assets list including phone and computer access instructions, password manager location, key accounts, banking, email, cloud, crypto wallet notes handled very carefully, social media preferences, memorialize or delete, and who should receive important digital files. Now let's pull everything together into a step-by-step plan you can actually do. Chapter 12. The Estate Planning Checklist, Your Next Right Steps. Here's a practical path that works for most people. Step 1. Inventory your life. Write down people, spouse, kids, dependents, assets, accounts, property, insurance, business interests, debts, mortgage, loans, where documents are, and key contacts, attorney, accountant, advisor. Step 2. Choose your team. Decide executor plus backup, trustee plus backup if using a trust, financial agent plus backup, healthcare agent plus backup, guardians plus backup. Step 3. Decide the plan. Who gets what? At what ages or milestones? Any special circumstances? Disability, addiction, creditor concerns, second marriage. Step 4. Create core documents. A common core set includes a will, a financial power of attorney, a healthcare power of attorney, an advance directive, and possibly a trust. Step 5. Align the assets. Update beneficiaries, confirm account titles, fund the trust if you have one. Recheck after big life changes. Step 6. Organize for the humans. Create an "in case of emergency" folder, digital or physical, with document copies, a contact list, an account list, not necessarily passwords, insurance info, funeral or burial preferences, optional, and your personal letter. Step 7. Review regularly. Put a recurring reminder, once a year for a beneficiary review, and immediately after major life events. If you do nothing else after this audiobook, do these 3 things. 1. Name healthcare and financial agents. 2. Make or update a will, especially if you have children. 3. Audit beneficiary designations. That alone prevents an enormous amount of pain. Closing. The point of all this. Estate planning isn't about predicting the future. It's about reducing harm. It's giving the people you love fewer decisions, fewer mysteries, fewer fights, and more stability, more clarity, more peace. You don't have to do it perfectly. You just have to do it intentionally. Thank you for listening to What You Need to Know About Estate Planning. Here's a bonus: a short personal letter you can record for your family. If you want, record a private message for your family. Keep it short. Keep it calm. Here's a template. Hi, if you're hearing this, something serious has happened. I love you. I don't want you to panic. The important documents are located at location. The person in charge is name. If you need help, call name at phone number. My wishes for medical care are in my directive, but what I want most is for you to support each other. Please be kind to one another. I love you.